Day for the most significant law to be passed since then, for the last 30 years.
Crime for someone who's already been convicted of a felony to possess any firearm.
Restrictions that New York passed on their statute about where you can have guns, places that don't have a sign.
And that's why gun owners wanted the Supreme Court to put the statute on hold. They have now said no.
No more hopes and prayers, thoughts and prayers. A vote is what we need.
Supreme Court decision in the case of a felon in possession of a gun might change the landscape of such cases forever. Let's dive into detail about the case of Jones versus Hendricks. Felons in possession. In the United States, there are laws in place that prohibit felons from possessing firearms. These laws, often referred to as felon in possession laws, serve a crucial purpose in maintaining public safety and reducing the risk of gun violence. While they are essential for protecting communities, there are also some issues associated with their implementation, and one of them led to a pretty big issue that the Supreme Court recently ruled on.
Take real cases up to the Supreme Court. We represent the parties involved. We do all the writing.
It was challenged by gun owners. Now the U.S. Supreme Court is allowing New York to enforce this gun control law.
Yesterday, I spoke about the Supreme Court's shocking decision.
That is looking out and reading all the cases decided by the United States Court of Appeals and state Supreme Courts.
Strict limits on guns outside of a home. Two Supreme Court justices say the New York law presents some serious questions.
Striking down Roe v. Wade. We've had a lot of discussion about that in our whole household.
To try to identify those cases that the Supreme Court might be interested in taking up and reviewing.
Jill and I know how painful and devastating the decision is for so many Americans.
The law in this state bans guns in many public locations and on private property unless there is consent.
The primary objective of laws that prevent felons from possessing guns is to prevent individuals with a history of serious criminal activity from having access to firearms. Felons, by definition, have been convicted of significant offenses, which can include crimes involving violence, drugs, or other serious violations of the law. Restricting their access to firearms is a measure aimed at reducing the likelihood of repeat offenses and potential harm to others. One key reason why this law is important is the concern for public safety. Studies have consistently shown that individuals with prior criminal records, especially those with violent or drug-related offenses, are more likely to engage in subsequent criminal behavior. By prohibiting felons from possessing guns, the law seeks to create a barrier that limits their ability to commit further acts of violence or use firearms in the commission of crimes. Preventing felons from possessing guns helps to address the issue of illegal firearm trafficking. Since felons are prohibited from purchasing firearms illegally, they may turn to the black market or engage in illegal means to obtain weapons. By enforcing restrictions on felons' access to firearms, law enforcement agencies aim to disrupt the flow of illegal firearms and reduce the prevalence of gun-related crimes. However, there are some challenges associated with the implementation of laws preventing felons from possessing guns. One of the main issues is related to the definition and classification of felonies. Laws differ across states, and what constitutes a felony can vary. This variability can create challenges in determining who is subject to the restriction, as individuals convicted of certain offenses in one state may not be in another. The lack of uniformity can lead to inconsistencies and difficulties in enforcing the law effectively.
Crime for someone who's already been convicted of a felony to possess any firearm.
Implemented by states, my administration is going to focus on how they administer it and whether or not they violate other laws.
Saying you can bring a gun in here, you can't go into with a gun.
Mr. Henderson turned over his firearms to the FBI before he was convicted.
And that's why gun owners wanted the Supreme Court to put the statute on hold. They have now said no.
This morning, though, we're here on a critical issue, gun violence.
Restrictions that New York passed on their statute about where you can have guns, places that don't have a sign.
As a condition of gaining bail before trial, the government has kept possession of the firearms ever since then.
I'm about to sign into law bipartisan gun safety legislation.
Those laws will still be in effect until first the Court of Appeals hears it in New York.
And would like the government to transfer those firearms, which he doesn't possess himself.
The families who, in fact, were victimized by the gun shooting that we've seen.
And then ultimately, if the Supreme Court takes the case, the Supreme Court hears it in Washington.
Another issue is the potential for disparate impact and unintended consequences. Some gun advocates have said these laws disproportionately affect certain communities, particularly minority communities, due to disparities in the criminal justice system. They argue that the laws contribute to a cycle of disadvantage and limit opportunities for rehabilitation and reintegration into society. Addressing these disparities and ensuring fairness in the application of these laws is an ongoing concern. Balancing the need to prevent felons from possessing firearms while also addressing concerns of fairness and rehabilitation is a complex task. It requires a nuanced approach that considers public safety, individual rights, and the potential for social and racial disparities. In this case, a man named Marcus D'Angelo Jones had a different problem stemming out from these laws. He was a convicted felon in possession of a gun, but claims that he actually didn't know his record wasn't cleared. Should a man spend his life in jail for a mistake? Was it a mistake at all? Let's find out. Marcus D'Angelo Jones' case. In the summer of 1999, the Columbia Police Department was conducting an investigation of Marcus Jones for possible involvement in illegal narcotics activity. The investigation included at least 4 arranged purchases of crack cocaine by undercover police detective Candy Kornman. In her undercover role, Detective Kornman had a number of meetings and telephone conversations with Jones. Each of the meetings was recorded on audio tape and all but one videotaped. After each meeting with Jones, during which she bought crack cocaine, a field test and chemical analysis was conducted and the substance sent to the laboratory for further testing. The result of the investigation was the arrest, subsequent trial, and conviction of Jones on distribution, possession, and conspiracy charges. On July 16, 1999, Detective Kornman spoke with Jones by phone and arranged to purchase 1/8 ounce of crack cocaine from him.
So the third party can either keep them in trust or sell them and give the money to Mr. Henderson.
And I know how hard it is, and I know what it takes to get it done.
So right now, those restrictions are in place. Gun owners are not happy about it.
Many people, there are over 1 million people convicted of felonies in this country.
I was there 30 years ago, the last time this nation passed meaningful gun safety laws.
James commented on the decision, saying she's pleased. Remember, the law, as it stands, strengthens requirements.
Later that day, she met Jones in a supermarket parking lot in Columbia, Missouri, and Jones sold Kornman 1/8 ounce of crack cocaine for $200. On July 20, 1999, Kornman again made arrangements to buy crack cocaine from Jones. This time, the two met in the parking lot of a different Columbia supermarket. Jones again arrived in the Chevrolet Celebrity, but this time with 4 other people. He was seated in the front passenger seat and motioned Kornman over to the vehicle and sold Kornman cocaine again. After the transaction was completed, Jones got back into the vehicle and was driven to a different area of the parking lot where another individual appeared to be waiting for him, and Jones allegedly sold them some of the drug too. On July 30, 1999, Kornman again communicated with Jones, and this time he agreed to sell her 1/2 ounce of crack cocaine. When Jones arrived at the agreed-upon location, Kornman purchased 1/2 ounce of crack cocaine from Jones. Earlier in the day, on July 30, 1999, Sergeant Brian Peaster, who was in charge of the Columbia Narcotics Unit, told Officer Christopher Kelly that an undercover detective would be meeting an individual near Officer Kelly's patrol area. Sergeant Peaster told Officer Kelly that he would radio Kelly after the meeting and that Kelly should follow the vehicle and attempt to find probable cause to stop the vehicle and identify the driver. Shortly before 5:30 p.m. that evening, Kelly received a radio call from Peaster telling him that Jones's vehicle was leaving the meeting with Kornman. Officer Kelly followed the car and ran the license plate number through his onboard computer. The computer search revealed that the license plate was registered to a 4-door rather than 2-door Chevrolet. Concluding that the vehicle was improperly registered, Kelly stopped Jones. Officer Kelly asked Jones for identification, and Jones gave him a Missouri driver's license that identified him as Marcus D. Jones. After writing down a warning for improper registration and for not providing proof of insurance, the identification information obtained by Kelly confirmed that the defendant had used different names at different times, a fact that the ongoing narcotics investigation apparently had not yet confirmed. After multiple other incidents of selling the detective drugs, Jones was arrested at an Amoco Quick Store in Columbia, Missouri on December 21, 1999 by Officer Benjamin White. Jones was not immediately read his Miranda III rights, but was transported to the police station in a squad car.
And in many cases, the value of the firearms can be quite high.
Today, for the most significant law to be passed since then, since the last 30 years.
And prohibits guns in sensitive places and requires background checks on all ammunition purchases.
Statute means what it says. It says that a convicted felon cannot possess a firearm.
I'd like to thank the leaders and members of the House and Senate for working together to get this done. I especially want to thank the families.
It doesn't say he can't sell a firearm that the government is possessing on his behalf.
While riding in the police car, the officers testified that Jones was very talkative and asked a number of questions. During the ride to the police station, and before the officers read him his Miranda rights, Jones explained to the officers his use of two different names. He told the officers that he was unable to obtain a driver's license after being released from prison in Tennessee, so he used his mother's name, Jones, from his Tennessee birth certificate. Jones also explained that his prior felony convictions were under the name Lee in Tennessee. Officer White testified that Jones never requested an attorney and did not ask that the questioning cease. None of the statements obtained on the ride to the police station were used at trial. Upon arriving at the police station, Officer White testified that Jones was processed and booked and read his Miranda rights. Officer White stated that he recited Jones his Miranda rights from memory rather than reading them from a card. White testified that Jones then agreed to answer some questions and told the police that he had used the name Marcus Jones to purchase a handgun from a pawn shop and that he had used the last names Jones and Lee. He also told the police that he had changed his name from Lee to Jones after getting out of prison, that he had applied for and received a gun permit, but that his gun had been seized by the police in an earlier incident. On November 19, 1999, a federal grand jury charged Jones with 6 counts, including distributing cocaine base and conspiracy to distribute a significant amount of cocaine base. On December 23, 1999, the defendant pleaded not guilty to these charges. Later, on January 21, 2000, an updated indictment reiterated the same 6 counts and added an additional count for carrying a firearm related to a controlled substance violation. Jones filed motions to suppress evidence and statements claiming that his Fourth Amendment rights were violated during a stop on July 30, 1999. He also sought to suppress statements made during his ride to the police station and at the station itself on December 21, 1999, arguing that he had not been informed of his Miranda rights. After a hearing held on April 17, 2000, the magistrate judge denied both motions, and the case proceeded to trial. During the trial, the district court admitted a videotape of the transaction between Kornman and Jones on July 20, 1999, despite the defendant's objection. The video also captured Jones's car interacting with another vehicle in the parking lot. Additionally, Officer Kornman testified over the defendant's objection that Jones expressed concerns about secret indictments that had recently been issued. On April 26, 2000, the jury found Jones guilty on 4 counts of distributing cocaine base and 1 count of conspiracy to distribute cocaine base. However, he was acquitted of the charge of attempting to distribute cocaine base. Then Jones was sentenced to 27 years in prison for the charges as well as possessing a firearm as a felon and making false statements to obtain a firearm.
Today, we say more than enough. We say more than enough.
No Democrat has ever tried to get anybody's guns. I mean, that's just a lie that they tell, and y'all ought to stop perpetuating the lie.
Time when this seems impossible to get anything done in Washington, we are doing something consequential.
To pass legislation that will do nothing to make Americans safer, but target our Second Amendment and our, sacred God-given liberties.
If we can reach compromise on guns, we ought to be able to reach compromise on other critical issues from veterans' health care.
During his trial, Jones said he was aware of his status as a convicted felon, but he believed his plea agreement had expunged his conviction. Jones challenged his conviction, claiming he was unaware of his status as a felon at the time he purchased the firearm, but his appeals all fell flat. A decade after Jones's conviction, the Supreme Court ruled in Rehafe v. United States that the government has the responsibility to prove that a defendant knew of his prohibited status and his possession of a firearm. The new precedent meant that the government would have to prove Jones knew it was illegal for him to own a firearm because of his felon status. However, Rehafe interpreted a statute and not set a new rule of constitutional law, so Jones was not able to challenge his conviction under normal procedures. Instead, he filed a habeas corpus petition. The district court dismissed Jones' petition, claiming a lack of jurisdiction. Affirming the lower court ruling, the Eighth Circuit said Jones couldn't challenge his conviction with a habeas petition because in the past he had an opportunity to raise his claims elsewhere. The Wild ruling. The Supreme Court ruled recently that Jones, whose conviction on gun charges was called into question by a high court decision, is out of luck. One of the most fundamental principles of criminal law is that no one may be convicted of a crime unless a legislature previously passed a law making their actions illegal. If there is no law on the books that, say, marijuana possession is unlawful, then a judge cannot toss someone in jail because they were found with a joint. The Supreme Court's 6-3 decision in Jones v. Hendricks, handed down now, does not directly attack this foundational principle. Instead, it does so indirectly by prohibiting many prisoners from ever challenging their convictions in court. Jones had argued that he should be allowed another chance to get his conviction thrown out following a 2019 court decision. In that case, the justices ruled prosecutors must prove that people charged with violating federal gun laws knew they were not allowed to have a weapon. Jones tried to reopen his case following the 2019 decision, but a federal appeals court ruled against him. The issue in the case is technical, though important, and involves when defendants can make their claims in court, not the facts of Jones's case. Justice Clarence Thomas wrote for the court that people who have used up their appeals don't get another day in court based solely on a more favorable interpretation of statutory law adopted after his conviction became final.
So other families will not have the experience and the pain and trauma that they had to live through.
To have their firearms, which are being held by the government, transferred to a third party for the third party to sell.
Atlanta, Buffalo, Uvalde, and for the shootings that happen every day in the street that are mass shootings we don't even hear about.
Until they can be given to the owner's children or something like that later on.
Their message to us was do something. I don't know how many times we heard that. Just do something.
Only 2 instances, newly discovered evidence or the court's new interpretation of a constitutional provision, authorize a second bite at the apple under a 1996 federal law meant to limit federal appeals, Thomas wrote. Most federal appeals courts would have allowed Jones to reopen his case, but Thomas wrote that those decisions amounted to an end run around the 1996 law known as AEDPA. Thanks to Thomas's opinion in Jones, we will never know if Rehafe invalidates Jones's conviction. That is, if he is innocent of the crime that caused him to spend nearly a quarter century in prison, because the court held that Jones may not challenge his conviction at all. The reason why is a federal law known as Section 2255, which ordinarily prevents federal prisoners from challenging their conviction or sentence more than once. After he was sentenced, but before Rehafe raised a cloud of doubt over whether Jones belonged in prison at all, Jones successfully petitioned a federal court to vacate part of his sentence. Thomas's opinion holds that Jones's pre-Rehafe challenge to his sentence blew his only chance to challenge his conviction, even though Jones couldn't have known before Rehafe was decided that he had a potentially valid claim that he is innocent. Section 2255 contains several exceptions which allow some federal prisoners to bring a second challenge, one of which provides that Jones may bring a second challenge if 2255's usual process is inadequate or ineffective to test the legality of his detention. But Thomas construes this inadequate or ineffective language very narrowly, so narrowly in fact that Justice Ketanji Brown Jackson mocks Thomas in her dissenting opinion for ruling that someone like Jones may only seek relief if the courthouse where a 2255 motion would have otherwise been filed has burned to the ground or been carried away by a mudslide. Under Thomas's majority opinion, it will not just be people like Jones, people convicted under the felon in possession gun statute, to whom Rehafe offered new hope, who will be denied second chances at overturning their convictions. Many other people who committed no crime whatsoever will also be denied these rare but occasionally legal second appeals and will languish in prison. In dissent, The 3 liberal justices wrote that the decision produces bizarre outcomes and disturbing results.
The people in Mr. Henderson's position will effectively lose all their ownership interests in their firearms.
For God's sake, just do something. Well, today, we did.
They won't be able to possess them anymore, but they won't be able to reclaim the economic value of them either. And that seems to be rather harsh.
It does include actions I've long called for that are going to save lives.
Justice Ketanji Brown Jackson noted that the ruling, coupled with other recent limits on appeals imposed by the court, have transformed a statute that Congress designed to provide for a rational and orderly process of federal post-conviction judicial review into an aimless and chaotic exercise in futility. Jones's lawyers continued to argue that he thought his record had been cleared and no longer was prohibited from having a gun. On appeal to the Supreme Court, Jones claimed the Eighth Circuit's ruling offers a strained interpretation of the law that raises constitutional concerns. Saying he is legally innocent, he argued that the ruling raises suspension clause concerns, barring him from any meaningful opportunity to show his conviction should be overturned. Daniel Ortiz, an attorney with the University of Virginia School of Law Supreme Court Litigation Clinic representing Jones, wrote in his brief, "Denying saving clause relief to someone convicted of no crime permits the suspension of cruel and unusual punishment in violation of the Eighth Amendment. Under any kind of proportionality analysis, punishment for no crime causes great concern. No matter how small the numerator of punishment, the denominator of crime is 0, a situation which is not only constitutionally but mathematically impermissible." The government did not completely disagree with Jones. It states that while the Eighth Circuit's ruling was correct, its holding was not. The disagreement surrounds the saving clause exception of the law, which the government claims must be maintained to allow federal prisoners a narrow opportunity to challenge their convictions. However, the government says that Jones doesn't meet the prerequisites for that narrow claim. U.S. Solicitor General Elizabeth Prologer wrote, "The saving clause exception to 28 U.S.C. 2255E's bar on habeas corpus petitions by federal prisoners preserves a narrow but important category of claims based on intervening statutory construction decisions of this court that established that a prisoner's conduct was non-criminal. Petitioner, however, cannot satisfy the strict prerequisites for such a claim, which require a showing of actual innocence that he cannot make. The court's decision balances 2 statutes, the general habeas corpus statute and an alternative post-conviction remedy for federal prisoners. Congress has traditionally said that prisoners challenging their sentences have to file a motion for post-conviction relief instead of habeas petition. Generally, prisoners cannot file a motion under both statutes unless one proves to be inadequate. Judge Thomas's view explained. To understand Thomas's reasoning, it's helpful to understand the history of how Section 2255 became law. Before its enactment in 1948, federal prisoners who wished to challenge their conviction were required to do so in the federal judicial district where they were incarcerated. This system was unworkable because it placed an extraordinary burden on federal trial courts that happened to be located in the same geographic district as a federal prison. Additionally, because prisoners are often incarcerated far from where they were tried and convicted, the court that heard a prisoner's challenge often did not have easy access to records, evidence, and witnesses it needed to weigh the prisoner's arguments. Section 2255 fixed this problem by requiring prisoners to challenge their convictions on the same court that originally tried and convicted them. This meant that the burden of hearing these cases, known as habeas petitions, would be distributed equitably among the federal district courts, and it also meant that the court most familiar with a prisoner's case would also hear any habeas suits challenging that prisoner's confinement. Ordinarily, Section 2255 does not allow a prisoner to bring a second habeas challenge if they were previously denied such relief, but the law permits a second challenge to proceed if 2255's ordinary processes are inadequate or ineffective to test the legality of a prisoner's detention. After a Supreme Court ruled in Bailey v. United States 1995 that a federal law prohibiting the use of a firearm in certain drug crimes should be read more narrowly than many courts had interpreted it. For example, most federal appeals courts permitted prisoners convicted under a broader interpretation of the law to challenge their convictions, even if they'd previously filed another habeas petition. Thomas, however, characterizes these post-Bailey decisions as an end run around federal law's limits on habeas petitions, and he construes 2255's inadequate or ineffective provision so narrowly that there are unlikely to be many cases where it applies at all to a prisoner fighting an unlawful conviction. In Thomas's telling, the main purpose of this inadequate or ineffective provision is to protect prisoners who are unable to bring a habeas challenge in the court where they were originally convicted, such as if Congress later passed a law eliminating that court. Indeed, in a footnote, Thomas suggests that the inadequate or ineffective provision may largely be a relic of an age before the federal interstate highway system was built, when transporting a prisoner to the judicial district where they were convicted posed difficulties daunting enough to make a 2255 proceeding practically unavailable. One problem with Thomas's reading of Section 2255, as Justice Jackson writes in dissent, is that it is entirely atextual.
This is yet again another move by Democrats to ignore the Constitution.
Obviously, they're gone, but will be an inspiration for us to do more. I'm not going to sign this bill into law.
I don't have a gun, but I don't give a damn about anybody else having one.
This also provides historic funding to address youth mental health crisis in this country.
Is over. H.R. 8 will be on the floor of the Senate, and we will see where everybody stands.
Both Thomas and Jackson agree about the history of why 2255 was originally enacted in 1948, to alleviate the burden placed on district courts located near federal prisons. But the statute itself contains no language whatsoever suggesting that its inadequate or ineffective provision applies only when the court that would ordinarily hear a Section 2255 case is inaccessible or unavailable. The entire relevant subsection of 2255, quoted in full, is an application for a writ of habeas corpus in behalf of a prisoner who is authorized to apply for relief by motion pursuant to this section, shall not be entertained if it appears that the applicant has failed to apply for relief by motion to the court which sentenced him, or that such court has denied him relief, unless it also appears that the remedy by motion is inadequate or ineffective to test the legality of his detention. Now, this language does place some burdens on prisoners. It normally precludes habeas relief if a prisoner failed to apply for relief in the court that sentenced them, and it also precludes most prisoners from seeking relief from a court that's already denied it to them. But the inadequate or ineffective exception to these general rules is broadly worded and does not contain any language supporting Thomas's interpretation of the law. AEDPA law. To understand Jackson's dissent, it's also helpful to understand the history of another federal law, the Anti-Terrorism and Effective Death Penalty Act of 1996, or AEDPA, which inserted many of the barriers facing prisoners who wish to file a second habeas petition into federal law. AEDPA is a significant federal law that was enacted in 1996. It introduced a series of changes to the federal habeas corpus review process and aimed to streamline the appeals process for individuals convicted of federal crimes, particularly those on the row. While the AEDPA has generated both support and criticism, its impact on the criminal justice system cannot be denied. One of the main objectives of the AEDPA was to expedite the resolution of habeas corpus petitions filed by state prisoners challenging their convictions or sentences. It imposed strict time limits for the filing of such petitions, limiting the ability of prisoners to pursue claims beyond specified deadlines. This provision was intended to discourage prolonged litigation and bring finality to criminal cases. Under the AEDPA, federal courts were directed to defer to state court decisions on constitutional issues unless they were found to be contrary to or an unreasonable application of clearly established federal law. This deference to state court decisions aimed to promote the principles of federalism and respect the judgments of state courts, limiting federal intervention in state criminal proceedings. Additionally, the AEDPA heightened the standard of review for habeas corpus petitions. It mandated that federal courts should not grant relief unless the state court's decision was not only incorrect, but also unreasonable. This stricter standard made it more challenging for prisoners to successfully challenge their convictions or sentences in federal court. A notable provision of the AEDPA was the imposition of a one-year statute of limitations for the filing of federal habeas corpus petitions. This deadline generally begins to run from the date when the prisoner's state court conviction becomes final.
Do you think the Supreme Court is broken, in your view?
I think the Supreme Court has made some terrible decisions.
thinking about voting for a proposal that allows them to get right on this issue.
Especially the trauma experienced by the survivors of this gun violence.
No more hopes and prayers, thoughts and prayers. A vote is what we need.
I work directly with the people who are most likely to commit these crimes or become victims of gun crime.
You can't compare 2013 to 2021. I think there are a lot of Republican senators
who lost their souls to an epidemic of gun violence. They lost their child, their husband, their wife.
This limitation aimed to promote timeliness and prevent lengthy delays in the resolution of habeas corpus claims. AEDPA also added 2 new exceptions to the general rule that second habeas petitions are disfavored. Even after AEDPA, such petitions are permitted if they are grounded in newly discovered evidence that strongly indicates the prisoner was not guilty, or if the Supreme Court hands down a new rule of constitutional law that applies retroactively to prisoners convicted in violation of that new rule. Thomas's opinion places a great deal of weight on the fact that Jones, who argues that his conviction is invalid on statutory grounds and not because it violates the Constitution, cannot fit his case within either of these 2 new exceptions created by AEDPA. As Jackson writes, the real purpose of the inadequate or ineffective provision was not simply to permit habeas cases to proceed if a faraway court is inaccessible or shut down. It was also to ensure that certain pre-existing post-conviction claims, say a claim of statutory innocence, could still be heard even if the statutory language Congress was adopting inadvertently barred them. Congress, in other words, wanted to make sure that Section 2255 only changed which court would hear a habeas dispute, and that it would not cut off habeas disputes that otherwise could have been brought. Over the years, numerous legal challenges have been raised against specific provisions of the AEDPA, leading to varying interpretations by the courts. The law has been subject to scrutiny and debate, with ongoing discussions about its impact on the rights of prisoners and the overall fairness of the criminal justice system. Critics have argued that the AEDPA has significantly limited access to federal habeas corpus relief, particularly for individuals who may have been wrongfully convicted or sentenced fatally. They assert that the stricter standard of review and the time limitations disproportionately hinder the ability to present new evidence or raise constitutional issues in federal court. While lawmakers in favor of AEDPA say that it has curtailed abusive and repetitive litigation, reducing the burden on the federal court system, they argue that the law has promoted finality in criminal cases and preserved the authority of state courts to interpret and apply their own laws. The AEDPA continues to shape the landscape of the criminal justice system and remains a topic of discussion among legal scholars, practitioners, and advocates. But in this case, it was the law preventing Jones from opening his case. When Congress enacted this act in 1996, it said prisoners could not file 2 post-conviction relief motions unless they were presenting new evidence or relying on a new constitutional law. The court took up Jones's case to decide if federal inmates who did not challenge their convictions because precedent stood against them could bring a later habeas challenge if new precedent overturns the prior precedent. The majority's ruling says they may not because of the limitation on successive post-conviction relief motions. Jones's attorney said the ruling was a great disappointment. Understanding this law matters because in Davis v. United States 1974, the Supreme Court held that Section 2255 permits prisoners bringing habeas petitions to raise both constitutional and statutory challenges to their convictions. So, if the purpose of the inadequate or ineffective provision, which was reenacted by Congress when it passed AEDPA in 1996, was to preserve prisoners' rights to bring the sort of suits that they have historically been allowed to bring, then Jones should be allowed to challenge his conviction. Justice Ketanji Brown Jackson wrote a separate dissenting opinion to argue the majority's interpretation was not Congress's intention, writing, "This stingy characterization does not reflect a primary aim of Section 2255E, which was to save any claim that was available prior to 2255H's enactment, where Congress has not expressed a clear intent to foreclose it. Jones's legal innocence claim fits that mold." Jackson claims the majority takes a nothing-to-see-here approach to incarcerating a potentially innocent individual and further writes, apparently, legally innocent or not, Jones must just carry on in prison regardless, since, as the majority reads Section 2255, no path exists for him to ask a federal judge to consider his innocence assertion. But forever slamming the courtroom doors to a possibly innocent person who has never had a meaningful opportunity to get a new and retroactively applicable claim for release reviewed on the merits raises serious constitutional concerns. The bottom line: federal habeas law is notoriously complicated, and statutes like AEDPA require prisoners to jump through an array of procedural hoops that are often ill-defined in the statute itself. To understand what's really going on in the Jones case, one must not only understand this complicated statutory regime, one must also be familiar with a philosophical debate between the Supreme Court's liberal and conservative factions, which has gone on for at least 3 decades. Left-leaning justices have long argued that the criminal justice system should primarily try to determine whether a criminal defendant has actually committed a crime, and that there should be adequate safeguards to ensure that someone who is wrongfully convicted can challenge that conviction. Meanwhile, justices on the court's rightward fringe have long argued that the primary purpose of the criminal justice system is to reach final judgments concerning an individual's guilt. Under this view, this need for finality can even overcome a claim that a prisoner is innocent. Thus, in his concurring opinion in Herrera v. Collins 1993, the late Justice Antonin Scalia argued that there is no basis in the Constitution for a right to demand judicial consideration of newly discovered evidence of innocence brought forward after conviction. At the time, Thomas was the only other justice to join Scalia's opinion.
You know who cannot afford to wait? The single mom looking to protect herself and her children from a violent ex who has just been released from jail.
It funds crisis intervention, including red flag laws. It keeps guns out of the hands of people who are a danger to themselves.
About 3% of the sales. But we are talking about the 100% of a life being snuffed out.
Who needs to register as a federally licensed gun dealer and run background checks before selling a single weapon?
As Republican presidents filled more seats on the Supreme Court, however, the approach favored by Scalia and Thomas was embraced by a majority of the justices. Thus, in Shin v. Ramirez 2022, a case involving an innocent man who was later freed after spending 29 years on the row for a crime he did not commit, Thomas complained in the court's majority opinion that a federal habeas court's decision to free a state prisoner overrides the state's sovereign power to enforce societal norms through criminal law and disturbs the state's significant interest in repose for concluded litigation. In Jones, Thomas does not simply repeat his philosophical commitment to finality in criminal convictions, he attributes that commitment to Congress, claiming that by enacting AEDPA, Congress has chosen finality over error correction. The upcoming change. The Bipartisan Safer Communities Act reassured gun control advocates while also appealing to those on the right concerned about preserving the constitutional right to bear arms. It passed in the Senate by 65 votes to 33. The House passed it the following day, with 14 Republicans joining the Democrats, and President Joe Biden swiftly signed it into law. Mr. Hayne was sitting in the Senate gallery with his sister for the vote, along with other shooting survivors. Their parents were shot, their mother fatally, by a gunman in 2005. It's not going to solve gun violence on its own, he says, but it provides a path for creating real change around guns. The package provides billions of dollars for mental health services and school safety, as well as grants to help states pass and implement red flag laws, which take guns away from those deemed a danger to themselves or others. The law enhances background checks for gun buyers under 21. It closes the boyfriend loophole to prevent domestic hurters from buying a gun for 5 years. It also clarifies and expands what a federally licensed firearms dealer is to ensure more buyers get background checks. And it creates new federal offenses for interstate gun trafficking and straw purchases, buying a gun on behalf of someone prohibited from possessing one. Lawmakers began to realize that safety is not just good policy, but it's good politics, says John Feinblatt of Everytown for Gun Safety, a gun reform group. Americans wanted action. They were angry and frightened after recent mass incidents in Uvalde, Texas, and Buffalo, New York. The sense of urgency mattered. Past efforts took months and lost momentum. The states had become laboratories for reform. 48 states and Washington, D.C. have collectively passed 466 new gun laws. Often these state laws were passed with bipartisan support without political consequences. We did not have this infrastructure 10 years ago, says Robin Lloyd of Giffords, a gun control organization founded after Gabby Giffords, a former congresswoman, was shot in the head in 2011. Mr. Feinblatt says the NRA's influence has waned. Every town is now twice the size of the NRA, which is why gun reforms still have a long way to go. That's all for today, folks. See you next time.